Greetings and welcome to another installment brought to you by Mohamed Marzooqi, Advocates and Consultancy, leading legal experts. Minor labour in accordance with Law Number 8 of 1980 and its amendments. The term juvenile means any person who is aged between 15 to 18 years of age, whether male or female. The law allows juveniles aged between 15 and 18 to work under official work permits. Taking into account the age of the juvenile and his or her health and physical capacities, the legislature has placed restrictions in the labour law legal framework that are in place for the benefit of the juvenile. These restrictions are age limitation. Article 20 of the Labour Relations Regulation Law stipulates that it shall not be allowed to employ children under the age of 15. This article prohibits the employment of a juvenile unless he is over the age of 15 years, whether male or female, citizen or expat. The Ministry of Human Resources and Emiratisation does not grant work permit to any emirati, juvenile or expat resident under the age of 15. The goal is to take into account the age of the juvenile and his or her mental and physical development, as well as giving him the opportunity to complete his basic studies. Registration of the employer to obtain documents related to the juvenile. Even though the juvenile has a right to complete a work contract, the employer is required by law to verify all the data related to him for commencing employment. This requires proving the age of the juvenile with a birth certificate as well as a certificate to prove his fitness for work. Additionally, the written consent of the juvenile's guardian is required. Where the statement of the juvenile or even the statement of his guardians that he is 15 years old and healthy will not be taken unless it comes with an official document certified by a competent health authority figure as stated in Article 21. This states, before employing a child, an employer shall obtain the following documents and keep them in his personal file. 1. A birth certificate or an official extract thereof or age estimation certificate to be issued by a competent medical officer and checked by a competent health authority. 2. A certificate of medical fitness for the required work issued by a competent medical officer and duly checked. 3. Written consent from the child's guardian or trustee. The law further stipulates that the employer shall keep a special register of juveniles containing all the data related to them, and this record shall be kept with the documents in addition to the contract of employment in the event of an inspection. Article 22 of the Labour Relations Law states that the employer shall keep at the workplace a special register of children showing each child's name and age, full name of his guardian or trustee, the child's place of residence and date of employment, and the job which he is employed. Provision of work of juveniles at certain hours of the night. Article 23 of the Labour Relations Law states that no child shall be made to work at night in an industrial enterprise. The term at night refers to a period of not less than 12 consecutive hours, including the period from 8 p.m. to 6 a.m. The clarity of the text of this article gives you an idea of the legislator's observance of the juvenile's age and the weakness of his physical abilities. This is further reflected in the sense of responsibility demonstrated by the legislator. Working at night for a juvenile has negative effects on the growth of the juvenile and his mental and physical capabilities. He would miss his home and it would separate him from his family. On the other hand, the work of a juvenile at night who lacks sufficient maturity makes him more vulnerable to mixing with bad companions. Prohibition of the employment of a juvenile in work that is cumbersome, dangerous or harmful to the health. Article 24 states that no child shall be employed on any job that is hazardous or detrimental to the health as defined in a resolution by the Minister of Labour and Social Affairs after consulting the concerned authorities. The employment of the worker in general in a hazardous or burdensome business is one of the priorities of the legislator. The main concern was on the health and safety of the worker. Similar to the attention the legislator gave to the health and safety of the juvenile working in a dangerous place of work have a greater negative consequence compared to that of an adult, and so the law prohibits the employment of juveniles in hazardous, difficult or harmful work. Prohibition of the operation of juveniles more than the working hours approved by the law. Article 25 mentions that the maximum working hours for a child shall be 6 days, intercepted by one or more breaks for rest, food or prayer, which shall amount in aggregate to not less than a full hour. Such breaks shall be so arranged that no child shall work for more than 4 successive hours. No child shall remain at the workplace for more than 7 successive hours. This article has set a maximum operating time for the juvenile, 6 hours a day, and also a maximum limit for continuous work is 4 hours, including the provision of a period of rest periods not less than 1 hour. In addition to the prohibition of the law on the employer to assign the juvenile to work extra hours or to work during rest days. This part is mentioned in Article 26. Children shall under no circumstances be required to work overtime or to remain at the workplace after the prescribed working hours or be employed on a rest day. So we've listed 5 legal restrictions approved by the law for the benefit of the juvenile, which are mandatory for all employers when employing any juvenile, in addition to the other conditions such that the license that will employ the juvenile is valid, as well as the payment of the required fees by the employer. And in the case of any violations of the restrictions approved by the law has determined who is responsible for the penalty in Article 34. The following person shall be held punitively responsible for the observance of the provisions of Section 2 and 3 of this chapter. Section 1, employers or their representatives. 2, a child's guardian or trustee, a woman's husband or guardian, or a minor's woman's trustee whose consent to the employment of children or women contrary to the provisions of this law. The second chapter deals with the employment of a woman, while the second chapter deals with the employment of juveniles. This article shows that the criminal responsibility for the implementation of the provisions of this article relating to the employment of juveniles primarily to the employer as well as to the guardians of the juvenile. This message is brought to you by Mohamed Marzooqi Advocates and Consultancy. We do have offices in Dubai and Abu Dhabi. Please contact us for your consultation. Alternatively, you can visit our website, which is www.ml-advocates.com.